the defense lawyer called me 1 month after we started my client's lawsuit and said, listen, I'd like to try and settle this case now rather than later. I said, okay, make me an offer. And the defense came out and said, listen, the only way we can make you an offer is if we get a discount on the value of your client's injuries and save you all the aggravation, the time, the effort, the money associated with prosecuting this case. You want to know what I said? Come join me for a walk through the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. My client suffered substantial and significant injury as a result of improper medical care at a hospital. And now, I get a call from a defense attorney that I know for a long time, and we had previously worked on cases together. This was someone who I respected, and I assume he respected my efforts as well as an attorney. And he called me up and we had a real conversation. He said, Gerry, we've analyzed this case. We'd like to try and resolve this now. But the only way we could do that is if we get a significant discount on what the real value and real injuries are worth. Otherwise, we'll just go forward with the regular litigation and it'll take 2 or 3 years to carry out. And we might have a conversation before trial. Otherwise, we may turn around and say, you know what? We've invested all this time and money and resources into defending this case. We've told our doctor that there are parts of it that could be defended. And we may just let a jury ultimately decide this case. So are you willing to go ahead and start negotiating with the understanding that any money that we offer is going to be severely discounted in an attempt to get your client guaranteed money right now? So here's what I said. I said, well, thank you for that, and I appreciate the analysis and I appreciate the straightforward approach you're taking, and I also appreciate your willingness to try and settle this case. But here's my concern. My concern is that my client still has ongoing medical treatment that she needs. My client will need additional surgeries into the future. My client still has ongoing limitations and disabilities, and her treating doctors have not indicated that she is anywhere close to having these conditions treated and fixed. So in all likelihood, these conditions are going to be permanent, and she's going to need ongoing therapy and rehabilitation after each of her surgeries. And she'll be unable to work for months after each of these surgeries. And her entire life is going to be disrupted. Her family life will be disrupted. It'll be turned upside down on its head. If I were to go back to her and tell her, listen, you guys are willing, the defense is now willing to try and settle this case, but at a very, very significant discount, I know that the first thing she's going to say is, why? What's the upside for me to go ahead and try and settle this now, knowing that I could get a fraction for pennies on the dollar of what my case is really worth? Why wouldn't I just go ahead throughout the course of the lawsuit and wait 2 or 3 years and get full value, assuming we went to trial and a jury came back in our favor? And I would have to tell her that she's absolutely right. That is an option, and that is something that can occur. And the defense attorney turns around and says, listen, you and I both know that there are no guarantees when you go to trial. You can have the best case in the world, you can have the best medical experts to support your case, and a jury may decide just the opposite. They may decide that my client, despite all of her failings, the doctor he's talking about, still is not responsible for your client's injuries. Or if they find that my client, the doctor, is responsible for her injuries, may find that it didn't cause and was not related to her suffering these injuries. Or on the other hand, the jury could come back and say, yes, the doctor was careless, and the doctor's carelessness caused the plaintiff, the injured plaintiff, your client, injury. However, they don't think that the injuries are as significant as we claim them to be. And my response to that was, you are 100% correct. And I agree with everything you just said. Now, that doesn't often happen where I will agree with my opponent, but I was having a straight, honest conversation with him, and it was important that I recognized that what he was saying was absolutely true. And it didn't detract from what my client had endured, and it didn't detract from her injuries, and it didn't detract from our case that establishes that the doctor and the hospital staff violated the standard of care. and caused her these significant injuries. So I said to him, what is your offer? I'm willing to listen, and I'm obviously, any offer you make, I have to go back and discuss that with my client. And he made an offer. And he made me an offer that was $500,000 as their very first offer. Now, what do I say about that? I'll say, thank you for that initial offer. I will go back and talk to my client, and I'll get back to you in a few days. Now, when I called my client to tell her about this offer, I said to her right off the bat, I said, I am not recommending, and I would not recommend, that you accept this offer. In my opinion, from what I have seen so far, and looking at your treating doctor's records and the extent of your injuries are worth significantly more than what they offered. But they are doing this primarily to try and resolve this case now, to avoid us having to go to trial, to avoid us having to spend tons and tons of expenses and time and effort and energy to prosecute this case. Likewise, they will be saving substantial amounts of money by making an initial offer that they think will be accepted, or they hope will be accepted, as well as saving on legal costs and expenses associated with prosecuting your case, knowing that they're going to have a very difficult time, if not an impossible time, to defend the doctor on what was done to you. And just as I told the defense lawyer, my client turned around and said, why would I want to accept a discounted offer now? Why wouldn't I want to go ahead and wait to be able to show and to prove to the defense that I have ongoing injuries, that my injuries are permanent, that I'm going to need additional surgery and therapy and rehab, and I'll be out of work for many, many months, and it may be impossible for me to return to work. And my client raised all of the same exact identical points that I mentioned when I spoke to my opponent in this particular case during that initial conversation. And I said to her, you are absolutely right. There is no real incentive other than if you absolutely needed this money now, and you knew that you could take this money after the expenses and after the attorney's fee, and take it and now go and invest it and do something worthwhile with it, instead of having to wait 2 or 3 years down the road of an uncertain expectation, of an uncertain outcome. And I told her, I said, there is no guarantee that we will win this case, despite the fact that they have made an early settlement offer, despite the fact that they believe that they are going to have a problem defending the case, because nobody, I don't care how experienced the attorney is, I don't care what type of case it is, I don't care what type of experts and how great they are. There is no guarantee and there's no possible way that anyone, an attorney or a client or a judge or anybody, can predict with 100% accuracy the outcome of what is going to happen when you go to trial. And that's the unfortunate reality. So both sides are actually gambling when they go to trial. And in order to minimize the risk that each side is going to experience, that oftentimes forces one or both sides to come to the table and to have serious settlement negotiations. And many times that works. However, there are instances where it does not work, and now both sides, or one side clearly wants to go to trial and let the jury make a decision about whether the doctor was careless, whether the hospital staff was careless, whether the patient contributed to her own injuries, and whether the wrongdoing caused my client all of this harm and injury. In that instance, now it'll be up to a jury, and then it'll be up to the trial judge on what to do with that verdict. And then it'll go up on appeal, and then an appellate court will have to decide what to do with that verdict. So there are a lot of unknowns. But my client was correct when she said, where's the incentive for me to go ahead and settle this case now? Even though it's a very substantial offer initially, I know, this is what she tells me, I know that if I wait, they will likely increase their offer. And I said to her, in this instance, you may be right. They may recognize that they have lowballed this case, and in an effort to try and resolve it and get rid of this case before we get to trial, they may ultimately come back and increase their offer. But I don't know, and I don't have an inkling yet as to whether or not their increase or possible increase would be significant. It might be very small or incremental. In that instance, you are now gambling away the opportunity to settle your case now for a guaranteed amount, or to take what's behind door number 2 and now gamble that you're going to get a much more significant offer if you wait a period of time. Well, there are risks associated with waiting. It's lost opportunity. It's a lost opportunity to take that settlement money and now invest it and do something useful with it. It's a lost opportunity to think that you will be getting a much higher offer down the road because more information may come out during the course of your lawsuit that it goes against our theories, that goes against some of the facts that we believed initially, in which case the defense may turn around and say, no, we're not offering anything else. If you want that offer, it may still be on the table. If not, let's continue forward. So why do I share this quick information with you? I share it with you just to open your eyes and help you understand how these types of cases work in the state of New York. I realize you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I hope you have a fantastic day.